Supreme Court allows Trump to fire FTC member while court mulls future of independent agencies. The Biden-appointed regulator will remain out of her post while the High Court considers overturning a 90-year-old precedent. By Josh Gerstein. 09/22/2025 4:41 p.m. Eastern Daylight Time. The Supreme Court is allowing President Donald Trump to keep a Biden-appointed member of the Federal Trade Commission out of her post for at least 3 more months, despite a century-old federal law aimed at limiting the president's power to fire such officials for political reasons. The justices said Monday they will hear arguments in December about whether that law unconstitutionally interferes with the president's ability to control the executive branch. If the court strikes down the law, as many legal experts expect, it will further hobble Congress's ability to insulate the leaders of regulatory agencies from political pressure. The High Court will take up the issue in the case of Rebecca Slaughter, an FTC member whom Trump tried to fire in March. Lower courts ordered Slaughter reinstated, but Chief Justice John Roberts temporarily froze those orders earlier this month. On Monday, the full Supreme Court, over the dissent of the 3 liberal justices, effectively extended Roberts' freeze, keeping Slaughter out of her job while the justices fully consider the constitutional issues. The High Court's brief order is the latest in a series of short-term and ideologically polarized victories for Trump on the court's emergency docket. The development puts the court on the brink of a move that conservative justices have been edging toward for years, overruling a 90-year-old precedent, known as Humphrey's executor, that upheld Congress's power to give federal agencies a degree of autonomy by insisting that their leaders be removed only based on misconduct or inability to carry out their duties. In attempting to fire Slaughter and another Democratic member of the FTC, Trump did not allege that they had committed any misconduct. He has similarly ousted other Democratic members of various regulatory boards in violation of federal laws protecting those members from politically motivated firings. The Supreme Court has used emergency rulings to temporarily greenlight Trump's firings of members of the National Labor Relations Board, the Consumer Product Safety Commission and the Merit Systems Protection Board. Those rulings signaled that the conservative majority may be poised to formally overturn Humphrey's executor, a precedent the High Court has already narrowed in the past decade. Ending Humphrey's would further expand the power of Trump and future presidents to control what were long referred to as independent agencies. But it's not clear how Slaughter's case will affect the legal battle over Trump's most high-profile firing yet, his bid to oust Lisa Cook from the Federal Reserve Board of Governors. Unlike with the other fired regulators, Trump claims that he has good cause to fire Cook and that he is thereby complying with the federal statute that limits presidential control of the Fed. Cook argues that Trump's bid to fire her is illegal, and 2 lower courts have agreed. The Supreme Court has also suggested that the Fed may be entitled to more independence than other regulatory agencies housed in the executive branch. An emergency appeal in Cook's case is currently pending at the High Court. Justice Elena Kagan complained in a dissent Monday that in Slaughter's emergency appeal and several others brought to the court in recent months, her conservative colleagues allowed Trump to oust existing officials even though Humphrey's remains the law of the land, at least formally. And they've done so, Kagan noted, not through written opinions but rather through a shortened procedural mechanism known as a stay order. The majority, stay order by stay order, has handed full control of all those agencies to the president, Kagan wrote, joined by Justices Sonia Sotomayor and Ketanji Brown Jackson. Fueling an ongoing debate about the court's handling of urgent appeals, Kagan faulted her colleagues for using such fast-track proceedings to effectively wipe out existing precedent without following the process of briefing and argument the court usually undertakes before doing so. Our emergency docket should never be used, as it has been this year, to permit what our own precedent bars, she wrote. Still more, it should not be used, as it also has been, to transfer government authority from Congress to the president, and thus to reshape the nation's separation of powers. In the 1-paragraph order Monday announcing the stay and the arguments on the president's power to fire FTC members, the High Court's majority offered no explanation for granting the stay and no rebuttal to Kagan's critique. It did, however, put the case on an accelerated timetable and take the unusual step of agreeing to hear it before a final ruling on the issue from the D.C. Circuit Court of Appeals.